Welcome to The Explainer. Today, we're diving into a genuinely gripping legal drama that asks a pretty fundamental question about government overreach. Now, picture this for a second. You're running your business, just a normal day, and suddenly, armed agents burst through the doors. They lock down the premises, they seize your cash, your property, and they do it all without a judge ever giving them permission. I know, it sounds like a scene pulled straight out of a mob movie, but this actually happened. And as you'll see, it triggered an absolutely massive constitutional battle. So it begs the question, can the government actually raid your business without a warrant? Well, this is the exact dilemma a constitutional court had to resolve. And honestly, the answer is way more complex than a simple yes or no. It really strikes right at the heart of how we balance our civil liberties against the state's duty to maintain law and order. Here's our roadmap for today. We're going to follow the exact structure of this fascinating case. We'll start with the warrantless casino raid, talk about the inner sanctum, explore the privacy continuum, look at the Constitutional Balancing Act, and finally, get to the final verdict. Let's get right into it. Part 1, the warrantless casino raid. This is the sting at Las Vegas Gold. Let's lay out the facts of the inciting incident, which really did play out like a true crime thriller over in the Northwest Province. Okay, so we can trace exactly how the authorities built this case. On August 26, 2004, a tip comes in about an illegal, unlicensed casino operating under the flashy name Las Vegas Gold. Fast forward 4 days to the morning of August 30th. Undercover agents actually go in, and they play the machines using marked trap money. Pretty textbook, right? Well, having confirmed the tip, that very same afternoon, Inspector Jacobus Erasmus executes a highly coordinated operation. He brings in a whole team of inspectors and police officers, and by the evening, the manager, Isaac Magajane, is arrested. But there was one glaring, massive omission in this otherwise flawless sting. The inspector never bothered to get a warrant. And what's truly staggering here is the sheer amount of evidence they seized entirely without judicial oversight. I mean, they locked up 60 heavy gambling machines, but they also dug right into the finances. They confiscated 4,490 rand directly from the cash register. And get this, another 24,120 rand straight from a locked safe. Now think about that for a second. Taking thousands from a locked safe without a judge's prior approval, that is an enormous assertion of state power. Which brings us to part 2, the inner sanctum. This is where we set up the ultimate clash of rights. Unsurprisingly, the manager sued, arguing his constitutional right to privacy was flagrantly violated. So how did the state justify bypassing the courts? They relied on Section 65 of the Northwest Gambling Act. Basically, this is a provincial law that gave inspectors the authority to search any licensed or unlicensed premises simply suspected of gambling. No warrant needed. Under this law, an inspector could just walk in, demand documents, interrogate people, and seize physical property entirely on their own authority. It's kind of a blank check for law enforcement. Now, when Mr. Magajane took his fight to the High Court, you might think he'd win easily. Actually, he lost. The High Court initially threw the case out. Their reasoning was that a commercial business just isn't a personal inner sanctum. You know, it's not your bedroom, it's not your family home. So they argued that because Las Vegas Gold was a business open to the public, constitutional privacy rights basically didn't apply to it at all. But thankfully, the High Court didn't have the final say. Welcome to Part 3, the privacy continuum. The Constitutional Court took up the appeal, and let me tell you, they completely disagreed with this rigid, black-and-white view of privacy. The justices relied on established precedent to explain how privacy actually functions in the real world. As Justice Ackerman famously noted, privacy is acknowledged in the truly personal realm. But as a person moves into communal relations and activities, such as business and social interaction, the scope of personal space shrinks accordingly. It's a brilliant way to illustrate the court's concentric circles of privacy concept. Privacy isn't just a light switch that flips off the second you walk out your front door. It's much more like a sliding scale. Let's look at how that sliding scale actually works in practice. In your inner sanctum, like your home, your expectation of privacy is at its absolute highest. Warrants are strictly required, no exceptions. At the complete other end of the spectrum, a fully licensed business has the lowest expectation of privacy because they have to accept warrantless administrative inspections just as a condition of doing business. But what about the middle ground, an unlicensed business? Well, it retains an attenuated or reduced expectation of privacy. It's definitely not zero. While a commercial casino has a lower expectation of privacy than your living room, it absolutely still retains some constitutional protection, especially when the state is aggressively hunting for criminal evidence.
And that friction brings us to Part 4, the Constitutional Balancing Act and the famous Section 36 proportionality test. This is the crucial moment. How do judges weigh the state's very real need to regulate gambling against a citizen's fundamental right to privacy?
To figure this out, the Constitutional Court used a 4-step framework. It's kind of like a legal stress test. Step 1, they analyze the nature of the privacy right, keeping in mind South Africa's history of abusive state searches. Step 2, they determine the importance of the law's purpose. And look, regulating gambling is undeniably essential for public welfare. Step 3, they weigh the extent of the limitation, like how badly did this specific raid trample on privacy? And finally, step 4, check for less restrictive means. Basically, could the state have done its job without completely ignoring the warrant requirement? While applying these steps, the court drew a massive, thick line in the sand between two very distinct types of government action: compliance versus enforcement. Compliance is just routine stuff, random administrative checks of licensed places to make sure they're following the rules. Enforcement, though, that's a highly focused, targeted investigation of an unlicensed spot specifically to gather evidence to throw someone in jail. The raid on Las Vegas Gold was 100% on the enforcement side. It wasn't some routine paperwork check, it was a criminal raid masquerading as an administrative inspection.
And when the judges really looked closely at the law that authorized this, the flaws were honestly kind of terrifying. The language of Section 65 was so vastly overbroad, it applied to any premises, which, yes, could literally include your private home. It allowed entry on mere suspicion, not even reasonable suspicion, which is a huge difference. It targeted items just capable of being used for gambling. So hypothetically, having a standard deck of cards could get your property seized. With absolutely no limits on time, place, or scope, the judges realized this law could theoretically allow a rogue inspector to raid your living room with almost zero legal justification.
And that horrific theoretical realization leads us right to Part 5, the final verdict. It was time to strike down the law and resolve the ultimate fate of the Northwest Gambling Act. Delivering the judgment of the court, Justice Vander West Susan laid it out loud and clear. Section 65(1) and 2 of the Northwest Gambling Act 2 of 2001 is inconsistent with the Constitution and is therefore invalid. The Constitutional Court struck down the law, ruling that warrantless searches designed specifically to gather criminal evidence go entirely too far. Now, the state did try to argue back. They claimed that requiring a warrant would allow criminals to destroy evidence and run away. But the court dismantled this argument effortlessly. A warrant wouldn't frustrate the state here. As the judges practically and kind of hilariously noted, 60 heavy gambling machines don't exactly sprout legs and run out the back door, right? Furthermore, remember the timeline? The inspectors waited 4 whole days after getting the initial tip to execute the raid. I mean, they had more than enough time to grab a cup of coffee, go down to a magistrate, present their undercover trap money evidence, and get a proper legal warrant. The court's decision is a powerful reminder that administrative convenience can never, ever be an excuse to bypass fundamental constitutional rights. So we're left with this final thought. Where does your expectation of privacy actually end when you step out of your home? As you process this explainer, ask yourself, how much power are you willing to concede to the state in the name of public order? Because the thin line between keeping society safe and living in a police state is very often drawn by the simple requirement of a judge's signature. Thank you so much for joining me, and I'll catch you on the next explainer.